Welcome to Business Files, as we continue our weekly discussions on matters relating to business, finance, and our economy. Welcome also to our viewers on the World Wide Web and to our loyal listeners on Real FM radio. We are happy to hear that we had over 130 hits on the web last week. A reminder to our small business owners and prospective owners of our two-day educational training seminar due to take place next week, Monday and Tuesday, April 26th and 27th. And it will be held at the Credit Union League offices in Belmont. We look forward to seeing you there. Now, on Business Files tonight, a major development this week that will have far-reaching economic, social, and other implications for the state of Grenada. The boundary settlement treaty signed yesterday with Trinidad and Tobago. I am Michael Archibald, and this week's edition starts right now. As we all know by now, the government of Grenada yesterday signed a boundary settlement agreement with the government of Trinidad and Tobago. There is little doubt that this is probably the most important treaty signed by Grenada over the last 2 decades and probably for the next 2 decades to come. The government has maintained that the best possible deal was struck with Trinidad, with equity and with fairness for both countries and for citizens of both countries. Government has also claimed that the agreement was fully in accordance with established international standards. However, criticism has come from certain quarters, and some sectors have said that the government has made a bad deal, giving up critical territorial waters to the regional oil giant Trinidad. Of particular concern is the division of Block 21, which we have heard so much about, and it is said to be the area where a large part of the oil and natural gas resources lie. On our program tonight, therefore, Dr. Carl Mitchell, co-chairman of the Boundaries Commission, and maritime specialist, Senator Ali Gill, will discuss the details of the settlement, what we have given up or not given up, and what we have. I am Michael Archibald. This is Business Files, and I'm your host, Michael Archibald. This week, we are pleased to welcome here and into your living rooms and into your bars and wherever you might be listening to Business Files, Dr. Carl Mitchell, co-chairman of the Boundaries Commission, and maritime specialist, Senator Ali Gill, to talk about the recently signed Boundaries Agreement with Trinidad and Tobago. Gentlemen, welcome to Business Files.
Thank you so much. Thank you for being here.
We want to spend most of tonight talking about the agreement itself. But Senator Gill, before we do start, 2 concerns that have been raised with me. There has been some concern raised by, in some corners, in some sectors, with regard to what is seen as the secrecy with which the negotiations were conducted. And given the fact that the NDC campaigned on a platform of openness and good governance, how do you respond to that concern?
I don't think that the concern has been raised in some quarters. I think it has been raised in only one quarter, and that is the official opposition quarter. And there's a fundamental difference between secrecy and confidentiality. There is confidentiality in negotiations and what we negotiated with Trinidad and Tobago, but there's never been secrecy. From the very first time that the Prime Minister went to Trinidad in August of 2008, accompanied by the Foreign Affairs Minister, the Honorable Peter David, and our co-chair of the Joint Boundaries Commission, Dr. Carl Mitchell, the nation was aware that the issue of boundary delimitation between Trinidad and Tobago, between Prime Minister Patrick Manning and Prime Minister Thomas was raised. And they both agreed that a Joint Boundary Commission should have been set up. From the very first time that the first meeting was held in Trinidad, in Port of Spain, in Trinidad and Tobago, the media was there. At every meeting, the media was present. At every turn, the Grenadian people was informed that the government of Grenada has put together a boundary delimitation team to negotiate the boundary delimitation issue between the Republic of Trinidad and Tobago and the state of Grenada. So it was above board. The people were informed. There were press conferences held. The Minister of Foreign Affairs spoke about it eloquently at the Parliament at every time. We had meetings in St. George's, at the Grand Bish Hotel. We had meetings at the National Stadium Conference Room. At every turn, the persons were aware.
Those meetings were about the boundary delimitation. Right, but not about what was actually being negotiated, contents within. That is the difference. And
that's the difference.
Let me say one thing. The concern that was expressed to me really was not from the opposition. I just wanted to clear that up. But the concern was about what is being actually negotiated, not about the fact that a negotiation was
what has been actually negotiated, that's an issue of confidentiality. Yes. But more than that, as we get into the nitty-gritty of the issue tonight, you'll see it's a technical issue.
Right.
And what we put together is a team of experts from Grenada and a team of experts from Trinidad and Tobago. Boundary delimitations have never been settled by a mob. It's never been settled by the public. It is technical issues of international maritime law.
That's the point that needs to be clarified. And
I'd like to get in on this. Maritime boundary delimitation the world over is carried out in secrecy and complete confidentiality. No country in the world comes out and says what its strategy is going to be, what is really going to be discussed, or anything. They get a boundary delimitation team. They gather a bunch of members for that team. It's a very multidisciplinary type of activity, the actual thing. So you get expertise in various disciplines required to be able to come to some decision on the boundary. The actual negotiations are carried out
in secrecy,
confidentiality. So when this is what happened. I remember the press always approached me in terms of what was happening. After the meetings, we had a press release saying this is what we discussed. Right. And I said after that I'm not saying anything. I said I wasn't prepared to say anything until we had the thing signed, sealed, and delivered.
And you're saying, Dr. Mitchell, that is standard.
That's standard. That's standard the world over.
And it's not normal to sort of consult.
No, you don't.
Okay.
Do that.
The second one, Senator Gill, before we go into the agreement itself, there is a lot of, and again, this did not come from the opposition, there's a lot of talk going around about an amount of $300 million that is supposedly promised to the government of Grenada by the government of Trinidad and Tobago as a result of the signing of the treaty.
There's absolutely no truth in that. I mean, I've heard $900 million.
No, I've heard 300 from various sources.
No, there's absolutely no truth to that. And when we begin our discussion with regards to the maritime delimitation issue, it will become clearer to you as well as to all of our viewers tonight that are really true. This issue of $300 million, and I've heard them just as you've heard them.
Right.
That's absolute craziness, really.
So there's been no sort of quid pro quo, of no promises, or anything?
No quid pro quo, no promise, no bribe, no corruption, no nothing than pure international maritime law.
I want to ask both you gentlemen, because I think your various members have said at different times, that you're comfortable that it was indeed carried out in accordance with the normal established international standards. Dr. Mitchell?
Yes. Well, it had to be.
Yes.
Because the whole purpose of the commission, you see, how these negotiations take place is that the normal and most popular approach to boundary negotiations is that you have negotiations and you establish your negotiating teams and you negotiate over a period of years. It took Trinidad and Venezuela 11 years to arrive at the boundary delimitation. Every year they were negotiating. Trinidad did exactly the same thing that we did on Venezuela. Venezuela established a negotiating team. Trinidad established a negotiating team. Over the 11 years of the period, Trinidad maintained its negotiating team. Okay? And so that's the normal thing. The thing about that is that, one, it's long-winded, 11, 12 years is the regular sort of time frame with not only Trinidad and Venezuela, but with a lot of other countries. Two, it's quite costly because every time you meet, you have your delegations and you have experts. Each state could apply or bring in international experts into its team, as the case may be. It's quite a costly thing. It runs into millions of dollars a year. In fact, at one time, when Grenada negotiated the first time around 1992-93, and I was PS in finance, we actually had a budget allocation of 1.5 billion
for the
just for the negotiation.
So you're comfortable that, in fact, the normal established international standards were maintained?
Yeah. But
Let me ask you,
the difference with us now is that we establish a boundary commission.
I understand that was your idea.
Right. Well, I like to say that
Grenada's idea.
Because the difference with that,
what is the difference between
the negotiating thing and the commission?
Yes.
The thing about the commission was they bring a bunch of technocrats together to apply the law, the law of the Sea Convention, you know? Because I say in the normal negotiations, you would have everybody, there'd be all sorts of considerations playing a part in the negotiations. That's why it's been so difficult to arrive at, solutions through the negotiating path. But I said that that if you establish a commission of technocrats applying the Law of the Sea Convention, and it had evolved. The Law of the Sea Convention had evolved with decisions taken by the International Court of Justice and by the tribunal and arbitrary tribunals. So right now, the latest ones were like the decisions handed down in the case of Barbados, Trinidad. I think that was an arbitral decision. Suriname, Guyana, that was an arbitral decision. We knew that the court had handled the delimitation in a certain way. So we had all the precedents established in terms of how you apply the law.
And given that this was mainly technocrats focusing on the law,
that was the whole idea, because you don't want to get it befuddled by politics and blah blah and people talk. And the purpose was that the commission would make recommendations for a boundary, a single boundary, to the respective governments. And then it would be up to the governments to say yea or nay. And then it was agreed with the government of Trinidad and Tobago that if the commission failed to attain that, we'll have no recourse except binding arbitration.
Listening to both you gentlemen at a different stage, there seemed to be a difference between the convention that the original negotiations or the previous negotiations were taking place under, which had something to do with the shelf, the continental shelf convention. And then lately now we have the Law of the Sea Convention. What is the difference between the two of them, and why was that change, why was that difference important? Maybe I could just turn to Senator Gill.
I always defer to my senior colleague who was
problem.
over 30 years.
Yeah. What was the change between the two of them, and why was that change important for Grenada?
Well, the change is very significant. The Law of the Sea Convention, as you know, the convention took place over a series of years, 1978 and 1982 it came to an end. And the convention had to be ratified before it came into effect. Before the convention,
Which convention is this?
This is Law of the Sea Convention, third United Nations Law of the Sea Convention of 1982, which came into effect in 1994 after countries agreed to the conditions, of establishing boundaries and 200-mile limit. That was the convention that brought about the 200-mile limit. Prior to that, the 1958 convention was the convention of the continental shelf, which gave coastal states jurisdiction over their continental shelf. Okay?
Regardless of the distance?
Yes. They said their coastal states were entitled to their continental shelves. On the basis of that, Trinidad went and did exploratory work on its continental shelf. on the northern extremity and every sort of thing. So they were on the shelf. Venezuela did the same thing. When we started negotiating with Trinidad in 1992 and 1993, the Continental Shelf Convention held sway.
Yes.
Okay? So if we had settled then, Grenada would have been completely off the shelf. You know, Trinidad would have started from its shelf.
Is that because the shelf extends?
Yes, on the deal, right,
yes.
right. So it was after the convention, the Law of the Sea Convention came along and said we establishing boundaries on the basis of geography and sort of equidistance between the thing, and it doesn't matter. Yes.
How far the continental shelf
yes.
goes.
You go to the water column and you go straight down, and if you whatever you have there,
that's it.
That's it. Whether you're sitting on shelf or not.
So why was that important for Grenada?
Well, it was important for Grenada because the shelf is the area that is most feasible, the most feasible area to exploit oil and gas resources.
I see.
Because it's shallow water, you could set up rigs, they have the technology, and so having shelf area is extremely important.
So it was better for us then that we can get onto part of that shelf.
Definitely.
Yes. Yeah.
Santa, you wanted to add something?
Yeah, just to put it graphically, so that persons who are viewing can appreciate. Under the 1958 Continental Shelf Convention, what Trinidad was advocating at the time, and Dr. Carl Mitchell in 1992-93 was a member of the team, which was then led by Senator Carl Aglin, now Governor General. The regime, the legal regime that existed at the time, speaks to two maritime boundaries, one for the water column and one for the continental shelf. The continental shelf, for persons listening, is a natural prolongation of the land, right? And Trinidad sits on the South American shelf. Not only Trinidad doesn't have a shelf on its own, it sits on the South American shelf.
So therefore it had claim for that.
Right. So at the time when they negotiated it before 1994, what Trinidad was saying is that we're entitled to all of our shelf, right? So that it is quite possible that Grenada would have had waters over the shelf, but Trinidad had the shelf. So we would have had the fish, but we couldn't pick up lambi.
That's what you meant by two boundaries.
Two
One's
boundaries.
a water
One
boundary.
delimiting the water space, the water column we refer to it.
But that water one would have been demarked by what? There's a two.
Well, you have to imagine that boundary delimitation is an imaginary line, right? And what it meant, because of delimit the water column by way of distance. But when you go to the continental shelf, the law at the time says
different distance.
Different regime. It says that the shelf belonged to the whole state, which is Trinidad and Tobago. So we would have had the water above the shelf, but not the shelf itself, which meant that we would have had the fish, but we could never pick up lambi on the surface of the continental shelf, much less to drill for whatever is on the continental shelf.
Well,
no,
okay.
So what is significant is that these boundary delimitation negotiations which we had with Trinidad and Tobago this time, in 2009, 2010, is the first time, the very first time in history that Trinidad and Tobago conceded that we are negotiating one maritime boundary.
Two.
And not two. And that's extremely significant.
Water right down to the land.
Water right down to the continental shelf, and that's extremely important.
Did the new convention, therefore, the law of the sea,
The convention.
Did it specify distance?
Yeah, geography.
What was this?
Well, that's why the equidistant, based on the principle
Between
of
the two
equidistance.
countries.
Yeah. What the convention did is that, to be practical about it, is that the convention put the onus on states to draw up provisional exclusive economic zones based on equidistance.
Provisional?
Yes, because it only becomes legitimate after negotiation, right? Okay.
After you've negotiated.
Yes, yeah, but in the meantime, you had to have some idea of what you have, and you had to have some rights for surveillance and this type of thing. So the convention said, all right, you states, draw up your provisional zones, provisional EEZs, and then negotiate to bilateral negotiations
to arrive at the final.
To arrive at the thing.
Finally.
Yeah.
All right. I want to later on have an actual look at the map to see if we could better explain to our viewers what you're talking about. But I understood that we had three main objectives, Senator, that the team had three main objectives.
Strategic objectives.
Yes. Can you quickly explain to the viewers what those three main objectives are?
Excellent. One of the most important things in our negotiations with Trinidad was to remain on what we call the tri-point. Trinidad and Tobago and Venezuela already negotiated the maritime boundary. As you would appreciate, we also have to negotiate our boundary with Venezuela.
Yes.
There is one point where the boundary of Trinidad and Tobago, Grenada, and Venezuela meets.
Yes.
That's the tri-point. And we wanted to remain we wanted to, at all costs, keep that tri-point.
What is the significance of
The
that?
significance of it is that once we keep that tri-point, in our negotiations with Venezuela, we would remain on the
You're
shelf.
already where you are.
We are already where we are.
Okay.
So we will not be giving up ground to Venezuela because of our Trinidad, because of a consequence of our Trinidad and Tobago negotiations.
All right, so that's
they're
the
extremely
first
important,
objective.
First objective.
All right.
Second objective was to stay on the shelf.
Based
Was
again on some of
to
the
remain
explanations you
on the
gave.
continental shelf.
Right.
Because as our chairman said, that is where the best prospects are. And it's much more feasible and easier for us to explore and exploit if there are any mineral resources. So we had to remain there. We had to remain there. And the other strategic point,
The third strategic objective.
the other strategic objective was to remain on the tri-point as well, on the Vincentian end. On the Vincentian end.
So that line will go from the close to
equidistant
Venezuela up
points,
to the other side, close to St. Vincent.
equidistant points. We have the equidistant points on the Venezuela end and as well as the St. Vincent end. On both ends, we remain on the equidistant ends, and we are on the shelf.
I'm going to want to try to show the viewers the lines that you're talking about.
Definitely.
But we first will take a break for our sponsors and Business Files. We'll be right back. Welcome back to Business Files. We have been speaking to Dr. Carl Mitchell and Maritime Specialist Senator Ali Gill, and we were talking about the recently signed treaty with Trinidad and Tobago. We were at the point of discussing the tripartite point and the line between that denotes the boundary. I'm going to hope my viewers can see this. Dr. Mitchell, if you can just lean forward a bit, and this is Trinidad. And this is Grenada up here. Right. So the tripartite point you were talking about would be this one down here. This is the one with Venezuela would be here. And the other one would be one here with St. Vincent. So then the two are joined. So that is what you're referring to. All right. So this line is approximately how far? It's in the middle between Grenada and Trinidad and Tobago.
Equidistant.
Equidistant. All right. Okay. I want to hold up a second map, which shows, again, Dr. Mitchell, if you would show us, this is the same line. And this is
2 points.
right, and then this one.
Point here with Venezuela.
That would be Trinidad with Venezuela. So this is a point now that is established between Grenada, Trinidad, and Venezuela. All right, okay. So when we are about to negotiate with Venezuela then,
We start
from this point here.
Yeah.
Oh, okay, all right. So is it safe to say that the three objectives of the team were achieved?
Were met. As I said, one of the first things that we achieved was to get a concession from Trinidad and Tobago that we're looking at one maritime route. Because as the team in 92, 93 would have said to us, when they went to negotiate with Trinidad in 92, 93, they got a lecture on geology and geoformology and so on, and rock formations. Now, what you have to appreciate, and the critical thing in ensuring that we have the point with Venezuela, as I said before, Trinidad and Tobago sits on the South American shelf. There is more shelf space on the Venezuelan end.
Would have gone further up.
There is more shelf on the Venezuela end than there is on Trinidad end. There is more shelf. In other words, Grenada is poised to get more shelf on the Trinidad, more shelf area
on the
Venezuela end than on the Trinidad end.
Again, if you can hold this up, so you're saying the shelf goes further this way.
The shelf comes further across.
Across, right, okay.
Governance
So
will have
Grenada is
bottoms
poised to
up
get
there,
more
going across like that.
here from Venezuela.
Right.
Yeah.
And there is an area, and if persons, and that is what we want to emphasize tonight, is that there is a fundamental difference between between maritime delimitation and oil and gas issues. I mean, most of the discussions I've heard so far.
But you can't really separate them, though.
Well, yes, you
one
can.
follows,
You have to.
one follows.
One follows the next.
The next.
But you only get oil and gas if it is in your area.
Yes.
But you delimit your boundary regardless.
But you have to get the boundary established first. I mean, that is clear.
That is clear.
But immediately after that, you want to start looking for your oil and gas.
If you're in an area where there is.
Yes.
If not, but there are other, and living and non-living is our fisheries regime. Our fishermen stands to benefit by fishing now on that shelf.
So you're saying...
So it's not just oil and gas.
Well, let's hope. There's some concern that the fishermen will now be running into problems with the Trinidad security. Why is that?
Why?
I don't know. I'm asking the question.
I don't think that's logical at all.
Has the line, because there was a belief that the line has been moved closer to Grenada?
No.
No.
Right.
No, and Grenadian fishermen we never had anything like a fisheries dispute between Grenada and Trinidad, you know. And the main reason for that is because they've had two distinct areas. Grenadian fishermen don't fish in that far south in terms of being really close to Trinidad.
Then why are you saying then that the Trinidadian fishermen will be better off?
Right. Because
they're getting part of the shelf area of Trinidad.
They
never used before.
Before you get to the shelf that we're speaking about, there's a deep water trough that Grenadian fishermen never ventured into.
Okay. All right. One final question. This one has a bend.
Right.
Why? This one is straight.
Straight.
And this one has a bend. What is the significance?
Right. The equidistance line have a bend, and the actual maritime line which we agreed to is straight. And Dr. Mitchell.
Can you explain that, Dr. Mitchell?
Yeah. Well, this was the result of the negotiation. In the convention, and I would say the evolution of the convention, is that you start with the equidistance boundary as the norm, and you have that boundary. And that you could change this boundary based on what I call special circumstances.
Okay.
You could amend the boundary.
So you start with this equidistant line, as you call it.
Yeah.
And the equidistant line is a slightly concave.
Yes, it depends on the your curvatures of your course and so on. Well, first you establish what we call the baselines. And Trinidad and Tobago and Grenada are two archipelagic states.
What does that mean?
Right, states with islands around. Now, the advantage of that is that the archipelagic states have the advantage of being able to draw baselines from one island to the other. Whereas if Trinidad were not an archipelagic state, the baseline would go along the coast and go,
But I'm assuming that applies to Grenada too, because we can draw it right up to Carriacou.
Grenada's baseline is from Point Salines, actually, come across right to the rock of Petit Martinique.
Okay.
So our baseline is that, and the Trinidad baseline is from the point here in the Bocas to a rock off Tobago.
Right.
So they came straight across. So the equidistance boundary follows the concavity.
And that is why this line...
That's why it's...
Again, I'm trying to hold it up.
That
is why this line has a curve.
Curvic.
Right, okay.
Curvicular.
Right.
So
but the agreed line now is a straight line.
The agreed line is a straight line, yeah.
Why the difference?
Well, that was... the Commission recognized being able, the one party or the Commission was able to change on the basis that the special circumstances existed which allowed us to change the equidistance boundary into
a straight line.
Straight line. Not necessarily a straight line, because Grenada was trying at one time to stay on the equidistance line as much as possible and then come across to the straight line to the other.
So, but even though we have gone to a straight line, we are still on the shelf that you thought was so important.
Yeah.
But the
But
moving...
we couldn't change this without the special circumstances argument.
Well, I want to come back. What is the special circumstance number one?
Right.
Because from a layman, just looking at it, it looks as if we have given up some ocean waters here. So why would we give that up? What are the special circumstances?
Well, the special circumstances were based on the length of the relative length of the baselines between Grenada and Trinidad. Trinidad has a length, of course, on that basis of 2.3 times Grenada's length. So that was that. The Trinidad and Tobago had also done exploratory work on the shelf, so they had a historic right to the shelf. And the concavity argument too was one of the arguments used there. So all of those factors combined constituted a special circumstance, which said then you could amend this line to establish the boundary.
So if I'm understanding you there, for the fact that Trinidad and Tobago, you're saying that the fact that Trinidad has a longer coastline
Yeah, that was
to the Grenada coastline allows them
to change
and have a claim on more ocean space.
Right.
And is that standard?
Yeah, that's standard. That's standard.
All of the decided cases, beginning with the Gulf of Maine case, that is the principle enunciated. So that, as I keep saying, the issue of a maritime boundary is an international legal question, guided by international legal principles. Trinidad and Tobago, they put forward the argument of historic rights and so on, which we were able to dismiss and so on and so forth. But what is most significant and the most persuasive argument is that they 2.3 times more our coastline. Trinidad have 70% of the coast and we have 30%.
Right.
In essence.
I just want to pin that down because that is, I'm suggesting that is what is generating a lot of the concern that says we have given up some ocean space.
So you have to understand
so
legal
there are two issues here.
And it's not even proper technical language to say that we've given up anything. We didn't have, because the equidistance line is not a boundary. The equidistance line is not a maritime boundary.
But you said it was a provisional boundary, and that is where you start from.
That's the starting point.
Right.
And then, look at what are the relevant circumstances, what are the special circumstances
that will create the change in the equidistance. All right.
If, and not only that, there is no formula. There is not a mathematical formula after how much you move.
Well, that raises another question. But let's go. The first one that concerned me, and I'm glad you said that we were able to throw that one out, that they had some historical claim.
Right, because you remember the continental shelf.
Because that suggests they could have just drilled somewhere and then come and claim it.
Right.
So you're saying that we threw that one out?
No, we dismissed that. We dismissed that argument.
All right, fine. So we come back now to this one about the length of the shoreline.
The length of the coastline.
On that basis,
and you can't get away from it. Any case law you pull, he points to that.
That's the
case law.
And you're saying because it was a provisional line, we have not actually given up something.
No.
It was just a provisional line from which you start negotiating.
Yeah.
Brilliant.
We didn't have anything in the first place.
You don't have anything in the first place. It's a provisional equidistance line. And the law obviously says that's where you start. Between opposite and adjacent states, you draw an equidistance line, right? And then you look at what relevant and special circumstances that prevails, that will influence any shift in the line. Yeah. And if there is any shift in the line, there is a test of what is called the test of proportionality.
The test of
proportionality.
What does that mean?
In terms of ratio of coast to marine space. So, for instance, what the agreement provides is that Trinidad and Tobago have 70% of the actual coastline. We have 30%. At the end of the day, they end up with 62% of the marine space.
Are you saying that they could have ended up with 70% of the marine space?
No.
Because they had 70%?
No, but the trend towards that
The trend might be towards that, yeah.
Bringing it, some sort of
So they have ended up,
compensation.
they have 70% of the coast.
70% of the
And they
coastline.
only
And that is the coast from Trinidad up right up to Tobago.
Tobago.
That's where you draw
Yeah.
the line.
So up to the pop.
And we had 30%, which starts at Point Celine right up to the rock,
To Pitty
Pitty Martini.
Right.
But in the actual marine space,
We had an
Trinidad have
inordinate-
62% of the marine space, and we had 38% of the marine space.
That's the end
and
of
what
it.
you have to appreciate is that equitableness does not mean the same as equal. In other words, because Trinidad and Tobago have 70% of the coast, that does not mean that they have to get 70% of the marine space. And that is why we said in the beginning, this is not an issue for, this is an issue for technical people. This is not an issue for the entire public to give its opinion and so on. This is a serious legal issue that we're dealing with.
All right. We're going to take a break, but I want to come back to another issue that arises out of this. Business Files will be right back. Welcome back to Business Files, and I'm your host, Michael Archibald. We have been speaking to Dr. Carl Mitchell, co-chairman of the Boundaries Commission, and Marine Specialist Senator Ali Gill. But before we go back into the discussion, I just want to remind the small business owners and prospective owners of the seminar that was being held on Monday and Tuesday, April 26th and 27th, at the Credit Union League building in Belmont. And it will touch on all aspects of small business, from financing to management, administration to marketing. And we look forward to seeing our small business participants there. Gentlemen, back into our discussion about the line. There's a lot of discussion again about that line being moved to our disadvantage because of this famous Block 21. There's speculation out there that we own the Block 21, or the majority of Block 21, and I'd like you to clear that up, Dr. Mitchell. And as a result of the movement in the line, it reduced, we either gave up, quote unquote, Block 21, or reduced our share of Block 21. Can you explain that?
Yeah, but before I do, just one point is that the convention says that when you're allowed to amend the provisional boundary, okay? But the basic objective of delimitation is that it be based on equitable principles. And equity means that both parties have to be satisfied with the solution that
With the outcome of it, yes.
Yeah. So they really make no provision in the convention for how you apply, there's, as I say, there's no mathematical formula in terms of what constitutes equity. Okay. So what constitutes equity, in effect, is some satisfaction from both parties saying, all right, this is fair. Fair and equitable, or just an equitable solution is what we aim at as the end product.
Well, I found it interesting that the opposition here is saying that we gave up too much, and the opposition in Trinidad is saying that Trinidad gave up too much.
Well, that's...
No, then we do fair and equitable. So both sides complete.
Well, maybe we've spread it spread it equally. Yeah. Now, the thing about I say you don't you don't lose something that you haven't got. The interesting thing about the Block 21 and how it came about is that how Trinidad has a well-established modus operandi in how they handle their oil and gas developments, okay? They're put on the open market. They've demarcated after doing all the seismic surveys around Trinidad. They've demarcated areas, blocks, for exploitation. And these blocks go into the international market for lease purposes. So every year Trinidad comes out with a map, a concession map. You get from the Department of Energy in Trinidad a concession map which shows where the different block areas are, and they have open for bidding.
Right.
And they have different colors to indicate they're open for bidding in a particular year. Now, a lot of the blocks that they've blocked off areas going right out on the Atlantic side, even though it's in deep water right now and economically not feasible to exploit, but they still have blocks for that, blocks for future consideration. Block 21 was a block that Trinidad had demarcated and never put out on the market because Block 21 was situated more in the Grenada side of the provisional equidistance.
So they never put it out?
Than Trinidad.
Because it's my understanding that they did put it out.
No, they identified it.
But they didn't put it out.
Okay. And they can't put it out for open bidding unless Grenada agrees. Okay? So that was the question about Block 21. What makes Block 21 interesting, and as Senator Gill, we never mentioned Block 21 in the whole discussion going on, but everybody knew that, this is a critical thing because Trinidad tried a few shenanigans which all revolved around trying to get
into Block 21.
The complete block 21.
Yes.
Their first position was actually to move Grenada nearly completely off the shelf. That Trinidad first recommendation was that they'd move this equidistance line 4 nautical miles up.
So much closer to Grenada.
Yes.
Yeah.
So that would in effect get Grenada off the shelf.
And also give 21 completely to them.
No, not completely. You still would have had a little touch.
Okay. But most of it?
Yeah.
Okay.
Most of it.
So what you're saying is that we never had Block 21?
No.
Because the understanding, again, roadside talk, is that we had Block 21 and that we gave up Block 21 in the negotiation.
No, we never had Block 21.
So what have we ended up with then? It's Block 21 is shared between Trinidad and...
Block 21 is shared with Trinidad. The difference is that if under equidistance, we'd have shared it 50-50. Okay. With the line drawn there, and I say we are trying to get as much as possible of it, we ended up with 40% of it, and the rest.
So, dealing purely with Block 21 now, can Trinidad now start exploiting Block 21, their part of Block 21, without the consent of Grenada?
That's difficult to do.
Why?
It's not impossible.
Why?
Well, because they never know where the actual action is going to take place. It could take place in the Trinidad area, it could take place in the Grenada area. That's why Trinidad's first proposal to us was, let's just share 50-50 regardless of proportion.
Can we do it? Can we start exploiting that part of Block 21 without Trinidad agreement? Or does it mean that both countries must agree to anything that happens in Block 21?
Let me just try this if I could clarify this. Block 21 is a description by Trinidad and Tobago. Right?
Okay.
We appreciate that. That could be Block 1 of Grenada.
Yeah, it doesn't matter. It's the area itself that's critical. Yeah.
Secondly, you have heard a lot about seismic surveys and data.
Yes.
Seismic surveys and data gives possibilities, speaks to the prospectivity of oil and gas deposits in a particular area on the continental shelf. It does not speak for certain or does not tell you exactly the point where on the block that there is oil and gas deposits. Yes? Now, the boundary that we have within Trinidad and Tobago is a political boundary between the states. Oil and gas deposits does not respect political boundaries. You may very well find, let us say, for instance, that there is a well on Block 21, yes, where mineral deposit is. The line may very well run right across the well. Yeah? So that
it's hard to say where the oil is. It could flow outside.
That's the point. It can flow outside.
But that is why it makes the question even more critical. Then how do Grenada or Trinidad exploit?
To speak to the treaty, in Clause 6 or Clause 7, speaks to the issue of joint cooperation. Where Trinidad and Tobago, it is most prudent that Trinidad and Tobago enter a joint exploratory agreement for oil and resources, for mineral deposits that straddles the boundary.
Right.
That's the most prudent thing.
So it is very difficult for any one of the two to do it independently.
Yeah.
And then according to the treaty, we should do it jointly. That's what I'm trying to get.
Yes. That's what I thought you
and
have
there's provisions in the
Right.
treaty for cooperation at that level.
At that level.
And it's up to the government to negotiate the terms and conditions, but it's established in the principle in the treaty that the revenues would be shared between.
But the details obviously will have to be worked out.
Would have to be worked out.
So
it might be worked out, on the basis of acreage, of respective acreage, or it might be worked out on the basis of just 50-50 with no questions asked, because they were saying you never know where it's going to be, so you can't be too specific about it, and it might be better. Now this also applies to the fact that when we went down there, our main concern was with the shelf, because we knew that the shelf would. And we knew about Block 21, because Block 21B, there's Block 22, and Block 22 is an operational block. This is where most of the gas is coming from right now.
Trinidad's gas.
Yes, it's leased by Petrotrin and Suncor.
And that is entirely
That's a
in
Canadian
Trinidad
company.
area.
Yes.
And
it's leased by Petrotrin and Suncor, and that gas goes to Point Fortin for LNG. So the possibility is that we think that if this block were to be put on the open market, that Petrotrin and Suncor would probably lease it, because it's a question of just moving equipment across from.
But then they would have to come to Grenada and have an agreement between
yes,
the government of
government
Grenada
would have
and the
to, the corporate.
But that sort of, I don't know if you'd call it a production sharing agreement or exploration agreement, will have to be worked out.
Revenue sharing, more or less, because they're developing
it. Yeah, that will have to be worked out.
Because you have to remember, Trinidad, the Trinidad government, 60% of the revenues. The Trinidad government comes from oil and gas, and the revenues come from lease payments and from royalties. And Trinidad charges royalties of 10 to 12.5% on the value of production in any particular block. So this is how they have every block that's operational. They know the production level, the value of the production, and they know the royalty. So they would do that for the whole thing, and then they would share the revenues.
Is there established methodologies for working out these revenues, and so that we can be guided?
Yes, definitely.
Definitely. So what you're saying in total is that we have decided on the boundary. We know where our limit is, and any further exploitation, it has to be to do with another negotiation, a further negotiation.
Right. That is
to
why I
decide the way
said,
forward.
that's what the Maritime Commission, Joint Boundary Commissions do the maritime boundary. Now the energy guys, the oil and gas specialists,
will have to come into
will come in now, work out the modalities and the percentages and so on.
All right.
It's absolutely important that we are on the shelf and we are on Block 21.
The other significant thing is that we discovered then that there were also blocks in the deep water area, just straight off from Grenville and this sort of thing, and that it's not only to the south that we're sitting on some good real estate, favorable strata. They describe these things after the seismic survey. They say you have favorable strata for oil and gas. That we also have favorable strata for oil and gas.
That's interesting.
Right on this. So we discovered that we
hold this up here. Again, this is Grenada here, Trinidad. This is the demarcation line. And you're saying it's not just down in the south
we
here.
have favorable strata here, the famous Block 21.
And also up
here.
And
Grenada and St. Vincent would be sharing some of that here.
Right. Okay. Do we have, Senator Gill, any existing agreements now? This company came and said all sorts of stuff that could impact on Grenada's rights to move forward, or Grenada's ability to move forward in exploring or exploiting, now that we know where our limits are? Is there anything that will hold us back now? Any legal agreements, any outstanding agreements by any company?
I think the nation is well aware with regards to the fact that we've had some agreement of some sort with RSM Corporation by one Greinsberg. I think there have been some litigations with regards to that, and Grenada has been, by and large successful with some of the litigations that has gone on before.
Yes.
Needless to say that Mr. Greinsberg seems rather litigious and very persistent, and he has filed recently new litigations. I think Greinsberg, the area that the previous administration signed up with Greinsberg has been far more. They have given Greinsberg quite a lot, literally all of the oil and gas acreage, all of our maritime acreage to Greinsberg. And then there is this GPG. GPG is a registered Grenadian company, actually. And they have given GPG an extensive area as well. Those issues are being currently dealt by the Office of the Attorney General. And the Minister of Energy, along with the Attorney General, I know is leading the charge with regards to those issues. And I believe that hopefully, in the not too distant future, those two issues can be adequately dealt with.
Right.
But as you correctly pointed out earlier on, the best case scenario is for us to delimit our maritime space, and to, when we develop our blocks, is to put it on the international market for bidding.
Yeah.
The highest bidder is the one who should win the area, rather than sitting with one particular company and getting. Because, as Carl pointed out a while ago, Trinidad and Tobago, the royalty is from 10% to 12.5% in the deepwater trough. The agreement that currently exists with GPG, the royalty to Grenada is 6%. Literally 50% of the royalty that's currently paid to Trinidad. It's absolute madness. You see, so that even the current market rate, already we started with a massive disadvantage.
But you are not, at this point, don't know for sure if it actually prevents us, or you're saying that those things have to be settled first?
Those things have to be dealt with.
Before we can move forward?
Those issues have to be dealt with. For the map that I saw, with regards to GPG, it appears that there is some area close to the provisional median line which was left alone. But Greinsberg, as I said, is far extensive, so that these things it's muddy, basically. At best, the issue of the outstanding agreements with Greinsberg and GPG is rather cloudy, and the Attorney General and the Minister and the Ministry of Energy, the Minister of Energy, and so on, they would have to work as best as they could to clear it up. Having said that, though, Grenada would have been in a much better position if none of these contracts existed.
Okay. In your experience as a marine specialist, and Dr. Mitchell, if you can come in on this, is it unusual for a country to sign off such a large proportion of the marine resources to one company?
Extremely unusual. It's practically unheard of.
In fact,
I'm referring to the Greinsberg one here now.
Yeah.
yes, it's I mean, it's unheard of. And we have an example very close to home. Barbados is trying to develop its oil industry, offshore oil and gas. And Barbados is doing exactly the same thing that Trinidad does. Barbados is demarcating blocks and going to international bidding for the companies.
So you have any number of companies.
Yes.
And if I understand, from what my understanding is that is not what happened in the case of Ginberg.
Not at all.
The whole thing, or most of it was.
And that thing was in it's only now we're discovering what went on in terms of the arrangements that the government, the previous government, had come across with both Grenberg and GPG.
So
GPG also had more than normal?
Yes.
GPG was 11 blocks, just straight up. I mean, I heard the former...
The lease fee. It's ridiculous.
So in addition to the fact that a lot was given to them, the royalty was also much lower.
And the lease thing was a joke.
The lease fee is what, $1,500 a month, literally? I mean, it's just a practical, just a joke.
Not even for one block. And they gave him the whole territory.
All right. So we have outlined the boundary with Trinidad. We know where that tri-point is, which relates to Grenada, Trinidad, and Venezuela. As far as the boundary delimitation is concerned, and I keep saying to Dr. Mitchell, Dr. Carl Mitchell, I find the term delimitation very interesting. What is the next step? Is it, I mean, but I suppose it's a question more for the government. Are we going to start talking to Venezuela, or are we going to send
Well, that's obvious. The next step is we're anxious to start talking to Venezuela right away. Because the nicety of this, the equidistant line, as we say, is that it allows us to start with that point at the equidistant point and puts us in a favorable position to...
Can I just show again? I'd like to show what you're talking about. Say that again.
It puts us in a favorable point here.
Sorry, this one is
to move across.
This one is better.
To move across here.
This is a Trinidad. This is a Trinidad-Venezuela line here.
Yeah.
This is our line here now, right?
It puts us in a favorable position to go across here
because of where we agreed on this tri-point here.
Tri-point here.
Okay.
So we starting from here, and we're moving here, and all the movement here is beneficial because of the shelf area that we get from Venezuela.
You get a larger shelf area.
Yeah. In fact, you know, that was how we are able to really sink in the argument about staying on the equidistant point, was that we told Trinidad that if we had to move 4 miles up, they were reducing Grenada's chances of getting that.
And since we want unity to come up.
Right.
All right. Okay.
So we use the unity argument, you know, that is soon going to be part of it.
There was a lot of talk about the oil rig that was supposedly, the rumor has it was over Trinidad oil rig that was over in our water.
Oh, yeah.
Was there any truth to that?
Yes,
and if there is, what happened to that?
That's an interesting story. That's during the PRG days.
Yes.
Okay, and in 1983, the convention finished in 82, as you know, and the Grenada established its provisional equidistant slide, okay? And after doing that, then they sent some their patrol boats to surveil it, you know, check it out and so on from both sides. When the patrol boats went to the south, they discovered a Trinidad rig well into what would be Grenada's territory. So Prime Minister Morris Bishop was very concerned, how do we handle this thing? And at the time I was in the area with Dr. Oliver Nelson. We were starting to do some work for Dalhousie University ocean studies on the marine spaced islands would get and how they'd manage it and this sort of thing. So he asked us as two Grenadians sort of, you know, what do you do about this situation? So we told Morris, he said, don't do a darn thing. Leave the rig where it is.
In our waters.
Yes, yeah. I say, then go and negotiate the boundary in Trinidad. And after you've done so, you'll find that you have inherited a rig. And I said, well, take it. Morris said, I take the point.
But I understand that the rig was since removed. And
but it was probably an exploratory rig, which probably provided all the information that allowed them to identify this famous Block 21.
We have to take another break. We will be right back. Business Files will be right back. Welcome back to Business Files. I am your host, Michael Archibald. We have been speaking to Dr. Carl Mitchell, co-chairman of the Boundaries Commission, and Senator Ali Gill, marine specialist. And we have been talking about the recently signed agreement with Trinidad and Tobago. Gentlemen, there's a lot of speculation going on again about, I think it's referred to as slant drilling, in which there's talk that if this is Grenada and this is Trinidad, right, that Trinidad could come down and then come across and take our oil. What is the possibility of that? And if there is a possibility, how do we counter that?
Well, slant drilling is one of the accepted sort of techniques for deep water drilling. Because it's cheaper to establish a rig in shallow water and so on, and you establish a rig in shallow water, and you slant drill into the deeper water. So, and the technology has been advancing by leaps and bounds in terms of that. The trough between the shells would below those troughs would be possibly pools of oil or gas that could be sand drill. There's nothing to really sort of prevent some sand drilling taking place, and in fact, it probably will take place in terms of if you're sitting on the shelf, I say, area, whether it's Grenada or Trinidad, the technology allows that to take place. So I don't think that this is really something that would constitute a problem in these circumstances at all, and it's a two-way street. We could say the same thing, that Grenada could just sit off on its other side and slant drill into what is essentially Trinidad. I mean, it's from both sides. So
but if one country starts doing it, can the other country detect it and at least raise the issue?
Well,
it's hard to say.
I don't know.
But the treaty speaks to countries doing work close to the border, the line. Should inform. Yes.
Of what they're doing, yes.
Inform the other state
disclosure in terms
disclosure
of that,
and so on. So you have full disclosure and so on.
Both parties have to disclose what their activities.
And that's as much as they can do, because it's difficult.
I don't think.
Okay, Senator, there was another question with regard to data. Who has data, right? I think the opposition party was saying they have data which they could have discussed with the government if the government had discussed with them before the agreement. And we are hearing that GPG has data.
That's one of the most, that's an issue that should raise eyebrows. Persons involved in the revolution, PRG, know for a fact that Russian seismic ships would have done some research and so on during the time of the revolution. But having said that, the UNCLOS, the Law of the Sea Convention, speaks to marine scientific research. And it must be said that all data, seismic or otherwise, touching on concerning the living and non-living resources in our maritime space belongs to the state of Grenada, right? If it is that the previous administration would have had information, data, with regards to what potentials that the state have with regards to marine mineral deposits. That should be somewhere in the relevant government department, locked away, in a very safe place. Whatever we do now belongs to the state of Grenada. This is not...
So you're saying any data that anybody has, it really belongs to the state?
It belongs to the state. It belongs to the state of Grenada, right? The state of Grenada should not be going to any company and saying, with its knees bent and so on, asking for data and so on. They should have permission. Any basic contract that any state gives to any of these oil companies, BP, Petro, all of these international companies, have that clause in a contract. Any data and so on, it must be deposited with the state, so that no company at the end of the day can hold a state as ransom and say, look, we have the deposit, we have data and so on, come acknowledge and you come for it. That belongs to the state, that's state property, as far as we are concerned, and the convention speaks to it. But even outside the convention, logics dictate that. The marine space that we've now delimited, it's part of Grenada. Grenada, is defined not by just our coastline. Grenada does not end on Granada's beach. Grenada ends where we have delimited the line with Trinidad and Tobago. All of that is Grenada. And we as Grenadians own between here and to that point. And we are entitled, as a matter of law, to all of the information. We need to know what happens there. And those data belong to the state. And that must be absolutely clear.
Dr. Mitchell, given your background and your history and your experience and your expertise, Grenadians are looking to you for your opinion, your advice, your thoughts on this matter. You are absolutely comfortable that Grenada has done the best that it could have done in this situation?
Oh, yes. I consider this a tremendous achievement, and I'm awfully proud of the performance of our team on the commission. The thing is that I'm also an economist, so I'm interested really in the economic implications of this. And the mere fact that we have, as it were, a new frontier
Yes.
for development. Grenada is a tiny island with only 133 square miles of land area, and quite limited in that respect. And the sea area that we will have at our disposal is going to be 20, 30 times maybe the land area. And the sea area has resources which could provide a new growth era for Grenada. It could help diversify Grenada's economy. We move in from fisheries and shipping from the aquatic and the marine side into oil and gas. There might be other minerals there, ocean minerals. There are possibilities too for sand mining. I know we have sand as a problem. Well, there's enough sand deposits not too far off the coast of Grenada to take care of our sand needs probably for the next 1,000 years in terms of that. So the marine sector has the potential to become the growth sector. I also think that psychology is very important, and the thing I feel that the contribution right now, whether we get any direct economic benefits from, let's say, oil and gas in the next 5 years or not, is that it gives Grenadians hope
For the future.
for the future. They know that we could move
Gentlemen,
in
I
that direction.
think we have pretty much run out of time. We were very kindly given a few extra minutes because of the interest being shown by the public in the discussion. So, Dr. Mitchell, if I can ask you in a few short words to just wrap up your closing statements, and then Senator Gill, I'll ask you after Dr. Mitchell if you can just wrap up with a few closing statements.
Yeah. Well, I'd wrap up by saying that this has been a long grind for me because I've been involved in it from the onset and the 1992-93 negotiations with Trinidad. Unfortunately, these negotiations were not continued until 2008. And again, as an economist, I felt that in terms of the benefit forgone by being so tardy in establishing the boundary, that Grenada has been losing a lot of potential growth and development. I mean, could you imagine if we had settled the boundary about 10 years ago? Right now, we might have been the Arabs of the Caribbean and along with Trinidad. But, it didn't happen. So I think that now that we've succeeded, Grenadians tend to have an inferiority complex every time you're talking about negotiating with Trinidad and this sort of thing. Well, they need not have already inferiority complex in this particular area because we could stand up to the world with the competence that we've had in doing this delimitation.
Okay. Senator Gill, a few closing statements.
Well, I think that the boundary which we agreed on has opened up a new economic frontier for the country. I think there are great opportunities, great possibilities. I look to the future with excitement, really. We must approach it with caution. We must deal with our living and non-living resources strategically. Sometimes in some of the African states, oil and gas has really been a cost at times. We manage it. So I believe that we must manage our resources properly and carefully so that it can benefit the people of Grenada. I look forward to negotiations with Venezuela. I believe that if we can do that in short order. The next 10, 15 years maybe can be very exciting times for our country. A country with a population of 100,000 persons, I believe that the possibilities and the opportunities that we believe we have from our maritime resources can certainly transform our country once and for all. So I think it's extremely important as well that in the debates that we have on the street, that we have in the shops, that we have on the beach, that it should be one that is enlightened. I believe that this is an issue that goes beyond political boundaries, go beyond party political lines. This is a national issue. I believe that we owe it to the Grenadian people to put the facts on the table so that persons can make informed opinions and give informed reasoning, because you have to appreciate that this document, the treaty, will be lodged with the United Nations. There is a reason, there is a document along with the treaty and so on, which is a public document for the world to see. Right? This is not just between Grenada and Trinidad and Tobago. The entire world will look at what we have done. And as Dr. Mitchell said, I think we are awfully proud of what we did. But I think for Grenada and Grenadians, the possibilities are great. I think that we must now negotiate with Venezuela. We also have to negotiate with St. Vincent, because I believe that there are possibilities on the side of St. Vincent, not just oil and gas, but in terms of yachting and shipping and everything else. And I think also we need to move with regards to looking at ocean governance in Grenada, and probably a Ministry of Maritime Affairs and that kind of a thing is probably the way we may have to go.
Maybe you might be the minister of that, and that probably is a hint to the prime minister.
But I also pay respects to the guys in the Port Authority.
Business Files will be right back with my closing comments. And we have just heard what I consider to be a very enlightening and very interesting discussion between myself, Dr. Carl Mitchell, and Marine Specialist Ali Gill. I have to say that I feel a little better about the entire agreement than when I came in here an hour and a half ago. The discussions will continue, the doubts will continue, the debates will continue, but I think as an independent commentator, it goes past party. It belongs to all in Grenada. And an old man said to me yesterday, he said whether the agreement was entirely or everything that we expected or not, in his view, half a loaf is better than none. And after speaking to Dr. Mitchell, I'm convinced that we have more than half a loaf. I look forward to the new negotiations coming up, because I would hate to see Grenada in a situation like some of the African countries where oil has turned out to be a blight rather than a benefit. So it would be important as we move forward how we use the flow and the inflow of money that comes from oil, and we look forward to hear how the government will negotiate those new arrangements with Trinidad and Tobago and with Venezuela. And with that, we say goodbye for this week, and I will see you again next week. This is Business Files.